We're going to talk tonight about intellectual property, or IP. Intellectual means something that comes out of your brain, and property is stuff that you own. So most stuff that you own are physical objects that somebody could break into your house and steal, or you can lose. Intellectual property is not tangible, so it's more like ideas, and but it's still something that you own and could be very valuable. These are 4 examples you might be familiar with of intellectual property. So the Rubik's brand, Pokemon, Dungeons & Dragons, and Lego. You'll notice on the logos, there are these symbols, the R with the circle around it and a TM. So the TM stands for trademark and the R stands for registered trademark. This means that the companies that own these brands own the name and the colors and the shape and everything about the brand, and so somebody can't come along and use it and sell something pretending to be Pokemon when it's not made by the Pokemon company. There are 4 types of intellectual property: trademarks, copyrights, patents, and trade secrets. Trademarks are symbolized by TM or R. Copyright is the C with a circle around it. And patents and trade secrets don't have their own symbols, but we'll talk about them more in a minute. But these are the 4 different categories of intellectual property. A trademark is a word, phrase, symbol, or design that identifies and distinguishes the source of a product or good of one party from those of others. Meaning, if you have something that has this logo on it, this red bullseye, it means it comes from the target company. And so somebody can't make their own thing and put that symbol on it and trick you into thinking it's something that's made by Target. A trademark lasts for 10 years, but it's renewable forever if it's still being used. If you stop using it, then it becomes, you lose the trademark protection and then anyone can use it. So these are some of the most famous and expensive, valuable trademarks out there. So, we talked about the Target bullseye. This is the famous logo for Apple. The swoosh for Nike, and the yellow golden arches, the M for McDonald's. Those are recognizable all over the world as being part of those companies. Now, you don't have to just trademark a symbol. You can also trademark a color. So this color right here, this magenta, is trademarked by T-Mobile. So you can't have a cellular phone product that uses that color unless it's T-Mobile. And similarly, this shade of brown is trademarked by UPS, the package delivery company. And so a company can't use that color brown and be a shipping company. Now, that's an important distinction, which is that a trademark only applies to a certain type of business. So you can use the T-Mobile color pink if you are selling ice cream or, making cars, something unrelated to telecommunications. Similarly, you can call your company Apple if you're not a computer or music company. Or TV, or there's Apple's in a lot of businesses, but you could come up with a business that let's say makes organic macaroni and cheese and call it Apple noodles. That would be legal because Apple doesn't apply to to food and that kind of thing. That's why you have companies like Delta Airlines as well as Delta faucets. Those are both famous brands or well-known brands, but they're in different areas, and so they can use the same name. Delta Dental is a third one. So all three of these companies are called Delta, but they're in very separate areas. They're in airline or dental products or faucets. And so you're not likely to be confused as to which company is which. All right, so the next category is copyrights, and you've probably seen this graphic at the beginning of movies. It says the unauthorized reproduction or distribution of this copyrighted work is illegal. So what it's saying is what you're about to see is copyrighted, so you can't copy it or distribute it without our permission. Copyrights apply to original works of authorship, including literary, dramatic, musical, and artistic works, such as poetry, novels, movies, songs, computer software, and architecture. So every book that's published is copyrighted. And so, for example, you take a Harry Potter book, you can't, photocopy J.K. Rowling's book and then bind it and sell it. That's copyrighted. Same with movies. So Rise of Skywalker, or a music album from U2, or a software package from Microsoft. Those are all copyrighted. So you have to buy them from the company that's selling them, and it's illegal to make your own copy and even just for your own use or sell it. And a copyright lasts for the lifetime of the author, as long as the author's alive, and an additional 70 years. There is something called a fair use exception, meaning that you can use small parts of a copyrighted work without permission under certain circumstances. And it's kind of, people argue about what is legal and what is not in this case. According to the law, it says brief excerpts can be quoted verbatim for purposes such as criticism, news reporting, teaching, and research without the need for permission from or payment to the copyright holder. So if you're, making a YouTube video that says, I hate the movie Frozen, and you show, here's a good example why I hate it, and you show a 5-second clip where a character says something stupid, that would probably be considered fair use. What you can't say is, I hate the movie Frozen, and just watch it and you'll see what I mean, and then just show the whole movie. That would be potentially criticism, but you're using the whole movie. And, the factors of what constitutes fair use is the purpose and character of your use, the nature of the copyrighted work, the amount of it that you use, and the effect on the potential market. Meaning, is your copy offering, preventing people or convincing people not to buy the original thing because they can get it from you? Or is it being used for something else? So on the right here is an example of a copyrighted piece of art. So, the character of Princess Leia is copyrighted as part of the Star Wars movies. But here it's being used in a parody, the Mona Lisa, and that would be considered fair use. The third category of intellectual property is called patents, and a patent is basically an invention, something that's useful. So in order to get a patent, you need to meet 3 requirements. It needs to have utility, meaning it has to be useful. It has to be novel, meaning nobody's thought of it before. And it also has to be non-obvious, meaning even if nobody's thought of it before, is it obvious that they could have thought of it? And that's kind of a judgment that the patent office makes. And if you prove that it's useful, novel, and not obvious, then the government will give you a patent. And a patent is basically a monopoly, meaning no one else can make this thing for 20 years. And during that time, you're the only one that can make it. But after that time, anyone can make it. And the patent application, you're required to basically describe how to make the thing. So you're giving up the idea and teaching everybody how to copy your invention. In return, nobody can do it for 20 years. And when I say useful, one of the requirements is utility or usefulness. There's a pretty broad standard as to what constitutes utility. So these are actual patents. On the left is a container for holding a banana, and on the right is a harness for a bird. It's questionable whether either of these two things are actually useful, but they were deemed to be useful by the Patent Office, and so there are patents for it. The last category is something called a trade secret, and trade secret is something that you keep to yourself so that nobody else finds it out. And if you can protect it, then a trade secret lasts forever. So until somebody discovers the secret, nobody else can make it, right? And examples of these is the recipe for Coca-Cola, the 11 herbs and spices in Kentucky Fried Chicken, and the algorithm behind the Google search engine. So in each of these cases, that information is not public, and the companies protect it and hide that information so that nobody else can copy it. But if you were to figure out somehow what the recipe for Coca-Cola is, then you can go ahead and start making Coca-Cola yourself. There's nothing preventing you from doing that. Coca-Cola is also a trademark, so you can't call it Coca-Cola, but you could call it something else and use the exact same recipe.